Matt Day here with Parsons, Graham and Day. Want to take a second to talk about transferring the venue of a case, specifically within the divorce and custody procedure in Oklahoma. So Oklahoma has adopted the UCCJEA, right? And the UCCJEA sets out that home state jurisdiction allows a court to make decisions about custody and visitation of a child. Now, there are emergency provisions in there in case that jurisdiction hasn't been established, if there's potential violence, things of that nature. I'm not going to get into that today. I want to talk about transferring venue under that, though. So, under the UCCJEA, there is an inconvenient forum, and you can file a motion to transfer the venue. The UCCJEA, obviously, it's a uniform law that has been adopted by a majority of states, and it provides that if there is a forum that is actually more convenient for the matter to be heard in, and that court can take it up reasonably quickly, then the court has the discretion to transfer the venue or the jurisdiction to that other court. In Oklahoma, we have a statute that says we would sub out the word state from the UCCJEA inconvenient forum statute and put in the word county if we wanted to transfer a case from county to county. Things that the court is going to consider would be whether or not the case involves domestic violence, what is the distance between the two courthouses, whether or not one of these states or counties has a docket that is generally busier or hasn't been developed yet or is backlogged, right? Where is the evidence going to be found? So where are the witnesses, where are the documents, where are the photographs? That probably is one of the biggest ones, because if we have to try and get in a photograph or a document, we have to have a witness to sponsor that. If we have therapists, counselors, teachers, doctors, those people would need to be subpoenaed to come in and provide testimony. And so transferring a case from county to county or state to state is, in Oklahoma, governed by the UCCJEA provisions under an inconvenient forum analysis. It is at the discretion of the court that is exercising jurisdiction or is exercising venue at that moment to decide whether or not to transfer. Another component is to make sure that the court that is going to take the case is willing to take the case. My experience has taught me that generally it's not a problem. Typically, the court that is receiving does not object or stop the transfer. There can be practical difficulties with transferring a case. It can delay proceedings. I had one case where the office hadn't mailed it out. The clerk's office had not mailed it out timely, and so it took time for it to get in the mail to the other county because they actually shipped the entire file. I've had other jurisdictions that just flat refused to discuss things with my office as we were trying to transfer a case. So there can be practical difficulties to consider when asking whether or not to transfer, and that's even if you're transferring from county to county in the state of Oklahoma. But can you transfer a case? Yes, you absolutely can. And it's especially true if none of the parties still reside in that county. All right. For more information, visit our website, www.pdtulsalaw.com. If you find yourself in a divorce or custody situation, call us today at 918-307-1529. We'd be happy to discuss your matter with you and provide you with an analysis of your situation and start planning how to get you out of it.
The purpose of this video is to be informative and not to provide legal advice. For legal advice, call a law firm and speak to an attorney about your particular case. None of the information provided in here is meant to establish the attorney-client relationship between Parsons, Graham, and Day and anyone watching this video.